Hi everyone and welcome back to another video. The former leader of the Reform UK party in Wales, Nathan Gill, has been jailed for 10.5 years after pleading guilty to charges of bribery, where he accepted bribes in exchange for giving pro-Russian speeches and other matters whilst he was a member of the European Parliament between 2018 and 2019. Now in this video I'm going to go through the facts of the case, and then I'm going to go through the judge's sentencing remarks so I can explain how the judge came to the sentence that she did. Welcome to my channel, Andy on Crime, where I talk about high profile criminal cases and other aspects of criminal law in England and Wales. And if you are on other social media platforms and you want to follow me, I am on TikTok and my handle is Andy on Crime1, and I'm also on Twitter or X and my handle is Andy on Crime. If you would like to support me, then you can click the link in the box above or in the description and sign up with NordVPN, where you can get a huge discount on a range of their plans and you will be supporting my channel. With all that being said, let's get into the video. So starting off with the facts of this case, Nathan Gill was elected as a UK Independence Party member of the European Parliament in July of 2014, and he served in that Parliament until Brexit took effect in January of 2020. He transferred from UKIP to the Brexit Party in 2016, which was the forerunner for Reform UK, before becoming leader of the Reform UK Party in Wales in March of 2021. Now, between December 2018 and July 2019, Gill accepted money in exchange for the delivery of pro-Russian speeches. Now, the case Gill was involved in centred around his relationship with a pro-Russian Ukrainian MP called Oleg Voloshin. Now, whilst he was serving as a member of the European Parliament, Gill accepted money from Voloshin in return for promoting pro-Russian narratives. He made statements in the European Parliament that were supportive of a particular narrative favourable to Russia on the issues relating to Ukraine, and he also wrote opinion pieces and gave media interviews pushing similar lines. According to investigators in the case, these statements were often scripted or directed by Voloshin rather than coming from Gill independently as a result of his own thought. Now, I've put a link in the description to the sentencing remarks of the judge, where you can read a fuller overview of each of the charges. There are 9 charges that he was charged with, and you can see the judge outline the background to each of them in those sentencing remarks. Now, WhatsApp and other messages on Gill's phone revealed that he had explicitly agreed to receive payments for making such statements, arranging events, proposing questions in Parliament, and contacting senior officials, in effect performing his public duties in a way that benefited foreign interests. There was also a suggestion, and this came out as part of the sentencing, that he attempted to involve other UK MEPs, though no one else has been named or charged in connection with this case as we speak. On the 13th of September 2021, Gill was arrested at Manchester Airport, where his phone was confiscated and analysed. He was interviewed again on the 3rd of March 2022 and answered no comment to all questions concerning the contents of his phone. He was charged in January 2025 of 9 offences of bribery and indicated not guilty pleas at a hearing on the 14th of March 2025. On the 26th of September 2025, Gill subsequently pleaded guilty to 8 of the 9 charges, contrary to Section 2 of the Bribery Act 2010. And on the 21st of November 2025, he was sentenced to 10.5 years in prison. Before I talk about the sentencing remarks in this case of the judge, I'm going to firstly talk about the offence of bribery. Now, Section 2 of the Bribery Act 2010 is the offence with which Gill was charged, and specifically, according to the Crown Prosecution Service website, he was charged under subsection 1 and subsection 3. Now, hopefully you can see the Bribery Act 2010 in front of you, specifically Section 2. And you can see that subsection 1 simply highlights that an offence is committed if any of the following 4 cases, as it states, are met. Now, the case involving Gill concerns section or subsection 3, where the offence is that R, the defendant, so Gill in this case, requests, agrees to receive, or accepts a financial or other advantage. So he gets something by asking or by being given it, which is not limited just to money, then this constitutes part 1 of the offence. And the second part of the offence is that the request to receive, the agreement to receive, or the acceptance to receive constitutes the improper performance by the defendant of a relevant function or activity. So in this case, Gill received monetary payments, cited by the prosecution to be about £30,000 in total, in exchange for delivering speeches and making statements which were written for him for the purpose of delivering pro-Russian messaging on Ukraine. Now, the irony of this case is that if Gill had actually held these beliefs himself, then he would have been free to say all of these things. That is not what this case is about. The case and the offence committed by Gill was that he was being paid to say something written by someone else at the behest of someone else which he did not believe in, and he only did so because he was receiving financial enrichment for him. Clearly, by his guilty plea in this case, he was not arguing that these were genuinely held beliefs. So I'm now going to talk about the sentencing remarks in this case, and I put a link in the description so that you can read them in full if you want to. They're about 6 pages in length. I do have my notes to the side of me, so you'll occasionally see me looking off camera. Now, the judge begins her evaluation of the sentence in the final third of page 4 of the sentencing remarks. And she highlights that the maximum sentence for a single charge of bribery under Section 2 of the Bribery Act is 10 years imprisonment. Now, when it comes to sentencing in criminal cases, judges are guided by sentencing guidelines dictated by the Sentencing Council. And offences are categorised based on 2 factors, culpability and harm. So culpability is relating to how involved a person is in the offending. So the more involvement, the more culpable they are, the higher the starting point for the offence. And similarly with harm, the greater the harm caused, the higher the starting point will be for an offence. So offences are categorised usually A, B and C, and then 1, 2 and 3, and then that corresponds to a grid which then has starting points and ranges for the offences. So the prosecution submitted that this was a Category A offence, so the most serious category in terms of culpability. Now, looking at the judge's sentencing remarks, it doesn't appear that she's commented on where defence counsel placed this, so I can only assume that they didn't disagree with this categorisation. Now, the judge who ultimately makes the decision on sentence agreed that this was a Category A offence due to the following factors: the abuse of the position of authority and trust, the time frame of the charges spanning 8 months in total, the motivation of financial and political gain, the sophistication of the offence, and the fact that Gill orchestrated the involvement of other MEPs. In terms of harm, the prosecution submitted that this was a Category 1 offence, again the most serious category. Defence counsel disagreed, making the argument that this was a Category 2 offence. The judge again agreed with the prosecution, highlighting that this was a Category 1 offence for the following reasons. Firstly, that these offences comprised of the integrity of a supranatural legislative body, the European Parliament, and it had a significant effect on public confidence and trust in democratic institutions. Now, being a Category 1A offence, and you'll hopefully see the grid up on the screen, that attracted a starting point of 7 years for each offence, with a range of 5 to 8 years. Now, with the judge having established a starting point, they then have to consider any aggravating or mitigating factors which can move the starting point upwards or downwards. Now, the judge highlights on page 5 that the offending necessitated consecutive sentences rather than concurrent sentences, so that pushed the starting point or the total sentence up to 16 years. The judge then considered mitigating factors in the case, including the previous unblemished record of the defendant, so the judge highlighted that this was of limited significance, the effect of custody on Gill's children, and the passage of time since the offence. The judge then determined that that attracted a reduction of 2 years from the 16-year point she had previously come to. And then the final thing that the judge had to do was to reduce the sentence to reflect the fact that Gill had pleaded guilty. Now, if he had pleaded guilty at the earliest opportunity, which he didn't, he would have received a 33% or a 1/3 reduction off of the sentence had he been convicted after trial. As he did not, and it was only at a later hearing that he did so, the judge granted him a 25% reduction on his sentence. Now, the way that sentences with multiple charges are sentenced can be complicated, so I'll try and explain this as simply as I can. Bear in mind that charge 1, there was no plea taken on that, and that will lie on the file. So the judge was sentencing on charges 2 to 9. So on charges 2, 3, and then 5 to 9, the sentence for each of those offences was 5 years imprisonment, all of them to run concurrently alongside each other. And then on charge 4, Gill was given a sentence of 5.5 years in prison, which was to run consecutively to all of the other charges. So that brought the total sentence to 10.5 years, for which Gill will spend 50% of that sentence in prison before he is automatically released on licence at the halfway point. He will also be subject to enforcement action under the Proceeds of Crimes Act to recover the money that he received in the course of these crimes. So to summarise this case, Nathan Gill was a member of the European Parliament between 2014 and 2020. Between 2018 and 2019, he took money to deliver speeches and conduct other engagements at the direction of pro-Russian actors in the course of his duties as an MEP. He was arrested and charged with 9 offences of bribery, pleading guilty to 8 of them. And when it came to sentencing, the judge sentenced him to 5 years imprisonment on charges 2 and 3, and then 5, 6, 7, 8 and 9 to run concurrently, so alongside each other. And then on charge 4, he was sentenced to 5.5 years in prison to run consecutively, meaning that the total sentence is 10.5 years, for which he will be released at the halfway point automatically. In terms of my final thoughts on this, it's concerning that someone who rose to the level of leader of a political party in Wales was corrupted by pro-Russian actors and was content to peddle their messaging in exchange for money. Now, there are likely to be more questions raised in relation to what other people at senior levels of the Reform UK party knew about Gill and his actions during this period. That scrutiny is only likely to increase, with Reform likely to take a significant number of seats in the upcoming local and then subsequent national elections. What do you think about this case? Please let me know in the comments down below. That's all for this video. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.